following this morning's decision from the Supreme Court, leaving in place a federal law that prohibits domestic abusers from having guns. In an 8-1 vote, the court ruled that the measure does not violate the Second Amendment. For more on that decision, we're joined by CBS News legal contributor and Loyola Law School professor Jessica Levinson. Jessica, break down this ruling for us and what we heard from Justice Thomas's dissent.
So what we heard from the majority, an 8-1 majority, is that there is a standard by which governments have to, there's a standard that governments have to satisfy, in order to impose gun control measures, but that it is possible to satisfy that standard. So what we have here is a court saying, yes, the standard is we look at the history and tradition in our country. And that's the way we determine whether or not gun control restrictions are constitutional under the Second Amendment. 16 years ago, the court said there's an individual right to bear arms that's part of the Second Amendment. Ever since that moment, it's been much harder for every level of government, local, state, and federal, to impose any restrictions. But what the court's saying here today is that doesn't mean impossible. And they were looking at an individual who was subject to a domestic violence restraining order. Federal law temporarily barred him from possessing a gun, and the court upheld that law and said, it is within our nation's history to say that people who pose a threat to others, people who are dangerous, they can be restricted in gun ownership. Now, you also asked me about Justice Thomas's dissent. What he said in dissent is, you misapplied my ruling from 2 years ago where I created this history and tradition test, that this doesn't fall within that standard. He also was concerned about the lack of process here, because we weren't talking about a conviction. We were talking about somebody subject to a domestic violence restraining order.
So what impact, if any, could this have on Hunter Biden's appeal over his federal gun conviction? We knew with his appeal, he would likely invoke Second Amendment protections.
This is not good for his appeal. Let's be clear, because what the court is saying here is we do allow, even though we created this really hard standard that's difficult for governments to satisfy, it is possible to satisfy it. And they point to some situations, and I would argue that it includes a conviction for a felony like Hunter Biden was just convicted. It includes those situations where we can say that you cannot possess a gun. And Hunter Biden's argument was that the federal law, which says that you cannot be a user of illicit drugs and possess a gun, that law was unconstitutional. And what I think the court is saying today is that type of law, now they didn't say it specifically, but that type of law actually is permissible.
So I want to ask you about a different case, Steve Bannon. He's asking the Supreme Court to let him stay out of prison during his appeal. He's supposed to show up July 1st. What are his chances here?
I think this is a long shot, a Hail Mary, whatever we want to use to say, I don't think it's going to happen, but this has already been rejected by a trial court judge, the Court of Appeals. Now he's going all the way up to the Supreme Court. And I think we should be careful. Conservative Supreme Court does not mean Supreme Court that wants to embrace somebody like Steve Bannon. He was convicted for contempt of Congress. I don't see in here a great legal reason for the Supreme Court to want to get involved in this.
Okay, Jessica Levinson, thanks so much.